avoid any opportunity for personal profits, or where the trustee makes such profits, that it is essential that the trustee would fully disclose that he made such profits, and that such profit is authorized. So it's not all gloomy that the trustee cannot benefit from the estate, but it must fully disclose, and such profits must be authorized by the particular trust instrument that the trustee is managing. And we also talked about the duty to act prudently and diligently in terms of the reasonable care, skill, and the caution that the trustee must exercise in managing the affairs of the estate or the trust that it has, and that the standard imposed by law on the trustee is a higher standard, because it's a question of trust. You are managing property. So what is required is not just ordinary person. It's a standard that is required of a reasonable expert in that particular field. A reasonable expert in property or estate management is what will be imposed on the trustee. So anything less than that can amount to a breach of trust. And then we mentioned again, we talked about the core principles that guide these various duties of trust, which is that it must act in good faith, and then it must always be in the best interests of the trust. And so we also mentioned the case of Spurs and Gowns, where the trust, the court uphold the duty of the trustee to act as an ordinary prudence man in business, and the same standard that is required, and duty of impartiality. I mean, being fair to all beneficiaries, which is that has been appointed on that part. And then we also talked about the administrative duties, and I think under the administrative duty, we mentioned duty to carry out the terms of the trust. We mentioned the duty to invest prudently, and we also mentioned the duty to keep accounts and render accounts to the beneficiaries. On the duty to keep account for the purpose of the beneficiary, you can see the case of Tito and Waddell. Tito and Waddell. Sorry. Tito and Waddell. T-I as like the Yoruba name, like Tito and Waddell. Waddell as in Waddell. It's a 1977 case. 1977 case. Chancery. Chancery is reported in Chancery at page 106. Tito and Waddell. So those are and the duty to accumulate, to take control of the property. So if from the moment you are appointed a trustee, you want to take charge of everything, every property that relates to the deed, and you take charge of that particular estate. So in terms of the statutory duty, we mentioned that the Companies and Allied Matters Act provides for the provisions of the statutory duties. We said section 830, section 832, and section 839. In terms of section 830, that section 830 of CAMA provides that the trustee must hold property in perpetuity, Section 332 relates to duty to account, to show proper account of the particular estates. And then sections 839 is duty against misconduct and mismanagement. 839, duty against misconduct and mismanagement. Those are the three provisions, three relevant provisions under the statutory duty imposed under CAMA. And under the law, under the trustee law of Lagos State, there are additional duties that are also imposed. The first one is duty to act diligently and honestly. which is some of the ones we have mentioned under common law in terms of under the fiduciary duty. And then the duty under this is under Lagos State trust law now, which is the duty to apply the fund for the intended purpose. So if the purpose of the fund is to improve the life of a beneficiary, and you are just you are collecting so much rent and you are keeping it, it's like you have a duty where the duty to administer someone's estate. And so let's say, for example, you have been appointed a trustee over a particular property for the purpose of a minor. And all you do is you collect rents, you sell properties, you invest, and you are keeping the money. The minor is not going to school, is not living properly. So those would amount to breach of trust, statutory breach of trust in that regard. So the purpose for which that particular trust, if it's to the benefit of the beneficiary, must be applied to that particular purpose. You cannot be prudent enough to begin to save the money while the child or the beneficiary wallows in poverty and is unable to achieve anything in his lifetime. So the purpose of the trust must also be achieved by that. And then you remember we said that it's not just one trustee, except in the case of Section 14 of the Trustees Act that says that the exception of sole trustee for when it comes to a corporation. Most of the time you have 2 trustees, 3 or 4. And then the question is that all of them must act jointly. The trustee law of Lagos provides that there is a duty for all the trustees to act jointly. So it will be in breach of their responsibilities if you are appointed 3 trustees and trustee A is going to Yaba. You know what I mean by going to Yaba? Literally, it's like it's on a different course, and trustee B is doing something else, and trustee A says that they are investing in crypto. Trustee B says that they are investing in real estate, and trustee C says we are investing in shares. So you now find the 3 of them acting disjointly. That would amount to a breach of the trust, a statutory duty that they owe the trust under the agreement. So there is a duty under the trustee law of Lagos, which is an additional form of duty, that the trustees must act jointly. They must act in unison. They must act with the same purpose, apart from acting for the object, the purpose for which that particular estate is created. They must act jointly for the purpose of that particular. Yes, sorry. Now, what about this? So the last one is duty to act, which is equitable duties. What are the equitable duties that are required? Sorry, just a second. I need to take water. All right, sorry. So, I was talking about the equitable rules that are required what are the equitable duties required? The first of the equitable duties required is the duty not to delegate. the role of a trustee is a personal role, and it requires some personal responsibility, and that the trustee would not be in a position to be able to delegate his property because it's a personal role that he has been given. And I'm sure from our knowledge of administrative law, you will recognize this doctrine of delegatus non potest delegare, which is that those whose power someone that you have that is a delegatee can also not sub-delegate. So the power to manage that particular estate has been delegated to the trustee, and so the trustee will not be able to delegate such power to someone else. So as an equitable principle, as an equitable duty, the trustee will not be able to delegate such power. Now, then he must act. This is quite a I don't know if I can call it a dicey situation. The law does not require that a trustee will get compensated. The law does not require that a trustee will be compensated. So there is an equitable duty that the trustee will act gratuitously. So when your friend appoints you as a trustee, except the trust instrument provides that you will be compensated, that position is not a position where you get any form of remuneration. So you are doing it out of love. You are doing it out of this idea that someone trusts that I can manage his particular estate. It's like, let me look at a situation where your best friend appoints you to help him or her manage his own estate for his own children. In the typical Nigerian setting, we can equate it to mean that those children that you're administering those estate for are also your own children. So in that sense, you don't expect to be paid for the role that you are performing over. So there is an equitable duty to act gratuitously. Remember, equitable duty to act gratuitously, which means that if the trust instrument or the trust deed provides otherwise, the provision of the trust deed would override that equitable principle. So where the trust deed or the trust instrument is silent over the payment of the trustee, in law, you are not entitled to any payment. However, expenses, all the things you must have expended, you are traveling here and all that, are part of the administrative costs that the trust estate would bear. But in terms of your own personal compensation, you have an equitable duty to act gratuitously. And so when you do that, it's like you are doing it for yourself. You are doing it for your own children. You are doing it out of trust or out of love. And then another equitable duty which the law also requires is that in case you are confused, you are not sure what to do in any case, you are not sure how to carry out your responsibility, how to ensure that that particular trust is promoted, you have an equitable duty to seek the court's guidance, to approach the court for proper guidance on how to implement or how to actually execute the responsibility of as a trustee. So if you check the case of Revicre is V as in RE, then Vickery is RVICKERY, Revicre. It's a 1931 case. I can't remember the year. Revicre, 1931. I think it's also Chancery. I think it's Chancery. It's Revicre, 1931 Chancery. I don't know. I think I'm not. Is it with 72 or 572? I'm not too sure whether 72 or 572. With Vickery, the 1931 case chancery report, 572, I think. So you also, so that's one of the, so the trustee, that's a case to show that you as a trustee, you cannot delegate your responsibility unless there is a provision in the trust deed or the trust instrument to that regard. So remember, that's one of those things we said earlier on. The first point of call when it comes to anything that has to do with the trust is to look at the trust deed. That's the primary document. It is after there is no provision in the trust deed, then you then move to statutes. And then before you can move to statute, ask yourself, as a trustee, as the settlor excluded a particular statute. If the settlor has excluded a particular statute, then that means we can no longer make recourse to the statutes, but rather we will then go to common law principles or any other form of default source of law. But the primary focus when you are trying to identify which of the how to fix a particular thing is first the trust deed. What's the trust deed saying, or what's the trust instrument saying? In the absence of the trust deed, you go to the statute, whether federal statute or state statute. In the absence of that, what are judicial authorities saying? And then, like we said also now, when you are still in doubt as to what is required, how the particular rights or duty is to be carried out, you have an equitable duty to approach the court for guidance in executing your task. And I said we should see the case of Vickery. Now, when would you have breached a particular if it's possible that all these duties you are in breach of those duties, let's say any of those, either the fiduciary duty, what do you call it now? Fiduciary duty that you have, administrative duty, and all that. What are the remedies that generally would accrue to the particular trust? Number one is that generally the trustee is personally liable for any form of breach of those duties. When we mean personally liable, you are liable from your own pocket. And that's why trust is something that a lot of people take seriously, and then a lot of people, at least in this part of the world, avoid a lot, because not only do you have an equitable duty to act gratuitously, if in the process of acting gratuitously, you incur liability or something that breaches that particular trust, you are personally liable. Your personal property is what would be used to remedy whatever it is that you must have committed, or whatever breach you must have. And then again, if they are personally liable, if there is some form of loss incurred by the estate as a result of your indecision or omission and all that, you'll be personally liable. And the other duty is one remedy is the remedy of restitution. If there is anything that you have taken from that particular what do you call it now, particular trust or particular estate, you have a duty to account or to return whatever it is that you must have benefited. So if it turns out that rather than take economy while traveling to Abuja, you are taking first class, the difference between first class and economy you will return that to the account of the particular. It doesn't matter that you don't have money, and that's where you are personally liable for some of those. So you must restitute. Restitute means return back whatever fund you must have benefit, or whatever benefits you must have benefited under that particular trust, as long as it's beyond the minimum or what the reasonable care it requires in that circumstance. And then you are going to account for profits. You cannot, for profits, not just profits that you made, but profit that you ought to have made if you have been diligent in carrying out your responsibility as a trustee. So it's not just profit now, which is another, sorry if I use the word annoying situation about managing trust. The trust, so you account for the profit you have made, and then the profit you ought to have made if you had been diligent in carrying out your responsibility. So that's another form of remedy in case that that the trust is entitled to, in case you have mismanaged or you have breached any of those 4 categories of duties that we have itemized. And then the 4th one is that another remedy that most beneficiaries seek is injunction. If there is an action that you want to engage in that the beneficiaries or other trustees categorize as something that can affect the status of that particular status of the particular trust or the trust property that can affect it, they can apply to court for an injunction to restrain you from carrying out that particular action. This is what you see most of the time when trustees begin to bicker and begin to have serious issues because one party or maybe someone who is in a better position to manage part of the estate or the part of the trust property is trying to take steps that either the beneficiary or the co-trustees think would prejudice, would affect negatively that particular trust. Those are some of the decisions, those are some of the issues that the remedies that the courts, that beneficiaries or trustees can seek in enforcing. Then, of course, the most important one, where you have breached all this, any of this, they can activate the clause on removal or suspension. You can be removed as a trustee, or you can be suspended as a trustee for a particular period of time. And then this time it can be by the Corporate Affairs Commission in the case of Nigeria, and then it can also be by the courts. So the courts can exercise some of the required basis of removal that we with all that the courts or the other members. And then in some cases, you can also, depending on who is affected, who is involved in the entire breach. For example, if a third party is part of that breach, that third party, I'm sure you know that by now, the third party can be declared as a constructive trustee. So even if that person is not a trustee as listed under the trust instrument, because he has put himself in a situation where he's interfering with the trust instrument or the trust property, for the purpose of, to the extent that he has interfered with that trust instrument, he can be declared a constructive trustee. So, for example, if I'm managing a trust and I have a girlfriend and I've taken part of the trust property to buy a car for my girlfriend, for that particular car, if it turns out that someone knows how I got the car, that's my girlfriend will be declared a constructive trustee of that particular. So you will be required to account for that particular thing. So that is one of the instances where that means that my girlfriend has unjustly enriched herself over that particular property, and then it will be declared a constructive trustee of that particular estate to the extent of the breach that
he or she must have paid, well, for including profits that are wrongfully made, they can be declared as constructive trustees. So it's not only, so sometimes it's about profits, or sometimes people is about, let me say, there was a particular incident where someone buys a trust property at a lower value. So the property, for imagine if a property is worth 50 billion and you bought it for 20 billion for that 30 billion which is below the average market price, you will be declared a constructive trustee of that particular asset, and you will be made to restitute, to return the balance of that particular fund to the estate in breach of your right. So but the question is there any form of defenses that a trustee can then claim if to avoid some of these rules that we have talked about? And one of the major what do you call it, relief is, in this case, is for one of the major is to trustee to say that in the what we call that breach is an innocent act. Innocent act in the sense that, or what we can refer to as acting in good faith. So sometimes the trustee, remember those two principles, acting in good faith and in the best interest of the trust. Sometimes some of the things we refer to as breach are things that are done innocently, not out of bad faith or not out of intention to benefit unduly from the management of that particular trust. So in that case, a major defense, one critical defense for a trustee is to say it's whatever he must have done that amounts to that breach of that trust is an innocent act. And on that basis, so he will be able to seek a defense. Another excuse for the breach is for the trustee to establish that that he had the consent of the beneficiaries or the co-trustees for acting. So we're in the process of exercising or carrying out the act that amounts to that breach. The entire group of trustees and the beneficiaries knew that he was going to make, for example, such investment in a particular type of assets, then such person would not be liable for breach of trust on the basis that if we can use the typical knowledge of volunty, so it's consent that members or the group of trustees actually consented to the action of the trustee, and in that case, that would exonerate the trustee. And then the trustee can also act that, well, in acting that they took all sort of judicial relief into consideration. So those duties and then consider for trust. Now, what is what I think, I don't know if time permits us. Maybe I will try and see if I can put up breach of, so that some of the cases that is relevant and some of the requirements relevant, we can look at them jointly at least before your exams and all that. Any question on appointments and duties of trustees? Any question? Any question?
Sir, please, can you restate the last defense you mentioned? Something about judicial. I didn't get it.
No, so judicial way, I'm saying that for reliefs, the courts would exercise judicial discretion. So it's not just everything that trustees or beneficiaries are approaching the court that someone has breached a particular use his discretion to determine whether that action amounts to breach. So it's a form of relief for the trustee. So it's not everything that the beneficiaries or the trustees think that that the action amounts to. For example, in letter stage, you can see the court act to apply its discretion. That to think that, well, even though this trustee has not breached that duty of care, the court still applied its discretion to remove them. So the same way you can apply to where it will benefit the beneficiary. So because most of the time what you find is that beneficiaries just don't trust trustees. They just believe the trustees are not doing enough. Even though I'm not sure the trustees, the beneficiaries themselves can do better than the trustees are doing. But they just believe that it's almost 1 year. Why am I getting $2 million in a year? If you are very diligent, I should be getting $10 million. So which means you are not doing your job very well. You need to come and account to me and all that. So sometimes the judges, judicial discretion always to protect the beneficiaries, or there is some form of bickering among the co-trustees. So that's another form of it. So as much as you bring your claim before the court that someone has breached, the court would use its discretion to determine whether such person acted in good faith or it's the beneficiaries that are being unreasonable in that circumstance. So it's a form of defense. So sometimes it's open to the trustees that, okay, you go to court and then the court will usually protect them in that circumstance. Do you understand?
Yes, sir. Thank you.
Does that make sense? You're welcome. Any other question? Any other question?
Yes, sir. Please, I would like to ask a
Any other
question.
question?
The Trustee Act of 1925. So you mentioned that it's a statute of general application, but what we know is that the limiting date for statute of general application is 1900. So how is it still a statute of general application?
The 19
Please, we can't hear you.
Of Trustee Act before 1920. The act was existing before 1920. So it was pre-independence. So, and it became part of the Nigerian.
Mister, it's been skipping. We didn't hear you at all.
Yeah. Nigeria adopted in 1925 as well. So it was an act that was improved upon pre-1900 and now.
Okay. Hello? 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 I'll send, if you can hear me, I'll send you a message on your clarification. Any other question?
All right, sir.
I can hear you. Hello? All right. If there's no any further question, um, this is where we'll end, and I will try to, I'll send a short or brief reading material on duties and the other things that we have discussed today. I'll try, let's make, maybe it shouldn't be more than 5 to 6 pages, and then so that will help us to have a good grasp, and the relevant cases, I will also try to include them in that. So in the absence of any question, thank you guys for coming. I hope to see, I hope to see you again. I'm sure someone else will come in to take the rest of the topics. All right, then take care. Bye.
Bye-bye, sir.
Don't